Good morning, everyone, and welcome to this joint seminar by Francis Taylor Building and Pinsent Masons on the government's recent proposals for further reform of judicial review for nationally significant infrastructure projects. And I'm delighted to say we have a really exceptionally strong lineup of speakers this morning, all of them prominent figures at the forefront of legal practice in infrastructure planning and judicial review. In a moment, I will provide a brief outline of what is proposed, and then I'll hand over to Rebecca Clutten and Hugh Flanagan, who'll discuss the reforms that have been put in place to date and their effect so far, to provide some context. We'll then hear from Robbie Owen, Claire Brodrick and Matthew Fox of Pinsent Masons on the practical implications of the proposed reforms. And then finally, Isabella Tafur KC and Hugh Flanagan will talk about the public law implications of what's proposed and possible obstacles to their achievement. Now, we hope to have a little bit of time at the end for question and answer. And so if you do have any questions as we're going along, if you could put them in the Q&A function within Zoom, and then we'll pick those up at the end. So just to give you a brief overview of the subject matter, the government published an announcement on the 20th of May, and the objective of what is proposed is to ensure that legal challenge is focused, proportionate, and does not create unnecessary delay to the delivery of nationally important infrastructure. It then runs through the steps taken to date, which we'll hear about so far, and then identifies two further measures, and these are described as optional mechanisms to the current NSIT consenting process to allow for proportionate protection, as it's put, from judicial review. Now, these are expressly said to be subject to detailed design and the passage of underpinning legislation. So we've only got the outlines at the moment to go on, and it's probably the subject of detailed consideration within government and hopefully some detailed consideration outside government. And we hope to use this seminar to start to identify some of the questions that feed into that process. So the two mechanisms are as follows. The first is a parliamentary authorisation mechanism, and that's intended to provide the greatest degree of legal certainty to the most critical energy projects, which would be identified on a case-by-case basis by the Energy Secretary and then made subject to approval by MPs. And what we're told is that the Energy Secretary would determine that a project should be given designation as of critical national importance. The House of Commons then votes to confirm that. There is then the normal process of submission and examination of the application for the DCO, but the final decision comes back to the House of Commons. There's a further vote, and if it is then approved, it's protected from judicial review on essentially the same basis as primary legislation, and therefore only on human rights grounds could it be subject to challenge. So that's the first of the proposals. The second is what's described as a challenge window mechanism, and that allows the Secretary of State to publish a draft decision. There are then legal challenges, an option for legal challenges to be brought, and then the Secretary of State has a chance to respond to those legal challenges before making the finalised development consent order, and that's combined with limits on the ability of people to raise new issues in any judicial review once the decision has been finalised. And this is an optional challenge window, so obviously you're not obliged to challenge, but if you want to challenge, that's your opportunity. And the idea is that the law will be changed so that if you wanted to bring up new issues that you hadn't brought within the challenge window, well, you wouldn't be able to do so. And it said this would help to expose and address any legitimate issues earlier, while providing certainty to developers and investors to press on with projects once consent has been granted. So that, by way of very brief overview, is the the proposal or the proposals, and we'll get more detail and thoughts from the speakers shortly. So with that background, I'm now going to hand over to Rebecca Clutten to talk a bit about what's been done so far and its effect. So over to you, Rebecca.
Thanks, Harry, and good morning, everybody. I'm just going to start by spending a few minutes really looking at the background to the reforms that are now being proposed and how we've got to where we've got to. And the starting point for that is November 2023 and the then government's Get Britain Building white paper on speeding up infrastructure delivery. Now, that white paper had identified the fact that the UK had made significant progress in infrastructure delivery over the lifetime of the 2008 Act, with examples being given of the delivery of over 1,000 miles of major roads built or updated, a 20-fold increase in offshore wind capacity, and gigabit fibre to 18 million premises. However, it recognised that notwithstanding that those achievements had been capable of being made, the delivery of major infrastructure remained too slow. It drew attention to the bureaucratic and costly nature of that consenting process and identified that that in itself was likely to result in a compromise to the UK's ability to meet its goals like net zero, economic growth and improved connectivity. In particular, that white paper highlighted that the delays and complexity that were impacting both on consenting and delivery. It identified that project approvals were taking up to 4 years compared to an ambition of 2.5 years, and that over half of projects considered had experienced delays, averaging around 9 months. The excessive level of paperwork was noted as slowing down decision taking and reducing transparency within the process. And in the post-consent phase, it was noted that legal challenges had increased, causing further uncertainty and cost. Now, of significance to today's discussion, half of all the legal challenges to major projects were noted as having occurred since 2020. And those factors were identified as ultimately contributing to UK infrastructure projects being amongst the most expensive globally. It identified that HS2 costs per mile were up to 13 times higher than similar European projects. The effect of those costs, of course, is firstly to deter investment in the UK and its infrastructure, and then secondly to place greater burdens ultimately on taxpayers and bill payers where the cost of those delays is recovered through the cost of the, for example, energy infrastructure that's provided. Now, in order to overcome those issues, the government proposed a 4-stranded reform agenda. The first of that strand of that was about speed, and the proposal, as we're familiar to, was to streamline decision making and to reduce approval times. In particular, there was a target to cut the consenting process, say from 17 to 12 months for fast track projects. There was an ambition to increase planning inspectorate capacity and to digitise processes as part of that speed agenda, and also to support local authorities involved in the process with funding in particular. The second strand was around certainty. So those proposals included updating and clarifying national policy statements with the ambition of reducing legal ambiguity, hopefully minimising challenge as a consequence, and providing clear policy tests for developers to meet. It was looking to introduce cost recovery for planning services to ensure that the system has capacity, and then looking also to extend the critical national priority status to additional low carbon infrastructure. The third strand was simplicity. The focus there again was going to be on minimising bureaucracy and reducing legal challenge, digitising systems, improving data access, and improving, as part of that, environmental data availability and streamlining environmental assessments. Fourthly, and finally, the delivery strand involved a proposal to establish a ministerial-led star chamber to oversee major projects and drive delivery, review of construction productivity, including the potential for 24/7 working on larger projects, and incentivising timely delivery and discouraging unnecessary delays. Now, one of the longer term objectives that was set in that white paper was then this fundamental review of both the planning and delivery processes, including consultation, which is obviously a matter that's been addressed recently, and also of relevance today, judicial review. Now, it was that objective that then led directly to the Banner Review. Now, that took place, it was published in October 2024, and it was Lord Banner KC's independent review into legal challenges against nationally significant infrastructure projects. And I say that review had been commissioned because of concerns that had been expressed in that earlier white paper that legal challenges to DCOs for NSIPs were causing undue delays, impacting ultimately the national economy and the public interest. So the review had the objective of looking at whether those challenges were excessive and how that process could be streamlined without undermining access to justice or the UK's compliance with its international obligations, and in particular, considering they're the Aarhus Convention. The review looked at the volume and the impact of challenges on the NSIP process, and it identified that since 2010, there had been 34 legal challenges at that particular point in time to DCOs, with about 22% of DCOs ultimately having been challenged, and with most challenges ultimately being unsuccessful. It did, however, note that although that was a relatively small sample size, there was increasing frequency of such challenges. The review found that those legal challenges, even when unsuccessful, were causing significant and unpredictable delays that was increasing costs. I think for national highways schemes, they identified that it could be up to £121 million per scheme in additional cost, resulting also in delay to public benefits and critically creating uncertainty for both investors and landowners who were affected by the compulsory acquisition process. It was noted that within the judicial review process as it then was, there were up to 3 opportunities or bites of the cherry to seek permission to bring a claim, and that was contributing significantly to delays as well, alongside also significant inconsistency in case management and the process through the courts, particularly in the Court of Appeal, and overall a lack of published performance data. So having established that there was a problem, Lord Banner looked at what practical steps could be taken to speed up the process through the courts, impacting not only the meritorious claims, but also the unmeritorious claims, and hopefully addressing some of the damaging delay and uncertainty. I think there were 8 recommendations made in total, some of which were just recommendations not to do anything. In particular, there was a recommendation to make no change to cost caps or to standing. It was noted that actually standing rules worked relatively effectively, and in terms of cost capped rules, it would not really be possible to meaningfully reduce challenges without breaching our international obligations under Aarhus. It was found that there was no justification at this time, although a matter to be kept under review, for having a specialist NSIP ticket. That's judges who are specialists in just the NSIP challenges within the planning court. And it found that there was also no need to create a different threshold for permission. The usual test was said to apply. The recommendations that did involve proposed action included streamlining the permission stages, in particular reducing the number of permission stages from 3 to 2, one in the High Court, one to the Court of Appeal, and moving directly to oral hearings for permission, eliminating the paper stage, and also introducing target timescales for decisions. There was also a suggestion that's probably just worth noting, was that there ought to be timely concession of permission if a defendant recognised that actually the case was arguable. They ought to be conceding at that point at an earlier stage to help reduce delays. Some suggestions were made in relation to improvements to case management, in particular the introduction of automatic pre-permission CMCs, case management conferences, to address procedural issues early on and to improve the predictability of the process. including the potential for joint position statements from parties before those CMC to clarify issues. In relation to appeals, the proposal was to set target timescales for appeals in the Court of Appeal, 4 weeks for a decision on permission, and for substantive appeals to be heard within 4 months. Also, there was an encouragement for similar targets to be proposed within the Supreme Court. And then finally, in terms of performance monitoring, it was suggested that the courts should be required to publish rolling data on case turnaround times so that it could increase the level of transparency and stakeholder confidence in that system. Now, those changes in relation to permission and target timescales, appeals, case management conferences were all made late last year through changes to the civil procedure rules. So, for example, we do now move straight to an oral permission case hearing in cases where permission hasn't been conceded, and there are tight target timescales for decisions at every stage in both the High Court and the Court of Appeal. Now, one of the lesser known consequential changes has been a change to a time limit for bringing an appeal against the decision of the High Court. And in cases involving NSIPs, that has now changed from 21 days to 7. That was a rule change that the appellant in a DCO challenge that I was involved in recently for Luton Airport fell foul of. In that case, a judgment dismissing their claim had been handed down by the High Court in late November. The appellant wished to appeal that to the Court of Appeal, and they lodged their appeal after 18 days. My client, Luton Airport, drew attention to the fact that the appeal had actually been lodged out of time, but first to that party and then also to the court. And the defendant Secretary of State indicated that they were intending to resist the claim, both on the basis of it being out of time and on the merits. Ladakhan subsequently, that was the appellant, subsequently submitted an application for relief from sanctions, and the matter was considered on the papers by Lord Justice Holgate, who directed that the matter be heard at a rolled-up hearing. That rolled-up hearing was listed for 2 days in May, and the first matter on to be dealt with at that hearing was this application for relief from sanctions and an extension of time. That application was, however, unsuccessful, and having heard a morning's argument on that, the court came back after lunch and indicated that they were not prepared to extend time, and that meant that the appellant's appeal was over. In particular, the change had gone unnoticed by the party's legal representatives, and the court found that there was no good reason for the delay. So that's just something to really be live to. I'm now going to pass over to Hugh, who's also just going to touch on the changes to when cases are declared totally without merit and the implications of those, which has also been the subject of recent case law. Thanks, Hugh.
Thanks, Becky. Good morning, everybody. So I'm just very briefly going to touch on the recent Stone Street Green case, where, as Becky said, the totally without merit change came into action, and it was an NSIP solar farm JR, and the grounds were heritage, alternatives and reasons. But procedurally, that was the interesting aspect. As Becky said previously, there were 3 bites of the cherry. So you had the paper stage, then you had the chance to orally renew, and then you had the chance to go to the Court of Appeal. Under the new regime, Stone Street Green showed how that can be cut down to 1. So there was, in the Stone Street Green jail, there was no paper stage because of the amendment where NSIP JRs now go directly to an oral hearing for permission. And then there was no application for permission to appeal, which was possible to the Court of Appeal, because the judge, Mrs. Justice Levin, refused permission to bring judicial review at that oral hearing. And importantly and critically, she certified the application for permission as totally without merit. And the new change means in those circumstances, there's no right of appeal. So all that we had was a hearing of 2 to 3 hours, an oral permission hearing, and judgment the next day. And so we were done and dusted from issue of the claim to final determination in about 4 months. from the start to finish of the claim. And even that could have been less. There were some delays in listing, so it could have been, I think, 2 or 3 months. And that is, I think, dramatically less than has been seen historically on some NSIP JRs. And then briefly, finally, as well, just 2 points to note. I think that the practice on the 2 JRs that NSIP JRs I'm aware of since the changes come into force has been to have a slightly extended oral permission hearing, because if you're not going to have the paper stage, the judge doesn't get the benefit of another judge's reasons on the papers. There is arguably justification for a longer oral permission hearing. So in this case, it was about 2 to 3 hours, and that's been the case on another one as well recently, the Corrie challenge. And then secondly and finally, on totally without merit, the test for totally without merit is well established as the judge being confident that the claim is truly bound to fail. And that is obviously, it's a high bar, but it's been shown, I think, through Stone Street Green and other cases recently not to be unachievable. And it is an extremely valuable and powerful tool now in light of the changes due to the new act. So it stops you going to the Court of Appeal, and even with the Court of Appeal's new expedited time frames, that really does cut a significant chunk of time potentially out of the challenge. And by way of example, in the Sizewell related litigation, there's been 3 Sizewell claims in the last few years, and in each of those there has been a finding of totally without merit by the court. So 3 separate totally without merit findings. So that and Stone Street Green does show you that it is achievable and certainly worth considering it if you're defending an NSIP JR. And so with that, I'm now going to hand over, I think, to Robbie at Pinsent.
Thank you, Hugh, and good morning, everybody. I'm going to make a few practical points on the parliamentary authorisation aspect of these proposals. And I very much welcome what the policy paper has to say about that in terms of giving Parliament a role for the consenting of critical national important energy projects. And I do think it's important that it's voluntary. It doesn't apply to all of those projects, but the applicant should be able to request it. The background to this, as far as I'm concerned, is that I and a few others were arguing during the passage of the Planning and Infrastructure Bill that there should be a parliamentary stage as a replacement for judicial review in the case of what we were calling then critical national priority projects, but essentially the same thing. We prepared detailed amendments and they were debated in the House of Lords, both at committee stage and on report last autumn. And we said there that a project was a critical national priority project if a national policy statement that has effect in relation to the application for development consent for the project specifically identifies the project as a critical national priority. And we thought that was important to give some accountability going back to the way in which national policy statements are formulated, scrutinised and approved by Parliament. And it's also important background here, because this concept of parliamentary authorisation for infrastructure projects is not new. Many of you will be aware of hybrid bills. This proposal by the government and what we were arguing for during the passage of the bill is nothing to do with hybrid bill procedure. It was very different, and there were two particular precedents here that I think are important. First of all, we have had, and they used to be commonplace, things called provisional order confirmation bills. Commonplace, particularly in the 19th and 20th centuries, where Parliament would confirm through individual bills orders that were made by ministers, but they were made on a provisional basis until they were confirmed. And that process is still on the statute book in some cases, particularly in relation to Scottish local legislation, although it hasn't been used since devolution. And then perhaps more relevantly, under the procedure that still applies to orders like development consent orders and other such orders that are subject to special parliamentary procedure, there's a 1945 Act that is still very much in existence and in force That's the Statutory Orders Special Procedure Act. And under that legislation, which governs, as I say, special parliamentary procedure orders, confirmation bills can be introduced under Section 6 after the Joint Committee report. So, for example, we see in Section 6(3) that it says where the Joint Committee report with respect to any such order that the order be not approved, the order shall not take effect unless it is confirmed by an Act of Parliament. And Section 6 then goes on to set out the procedure that would apply there for confirmation bills. And we modelled the amendments tabled and debated in relation to the bill last year based on that process, but adapted to be suitable for DCOs. And we envisaged for that procedure an abridged and a timetabled parliamentary process with one main stage, a joint select committee. So, as I mentioned earlier, nothing like hybrid bills, focusing on the right for interests outside of Parliament to petition against the DCO confirmation bill, really in two instances. First of all, in cases involving compulsory acquisition, that was important for human rights grounds. And secondly, to petition against the bill in relation to matters not covered in the preceding examination. So that was some background, and government has clearly had regard to the thinking that went into that. And Rachel Reeves said in May, when this was announced, that she wanted to put Parliament back in control, or a phrase to that effect. And I think, turning to the policy paper, just a few concerns and observations with the caveat, as Harry mentioned earlier, that the design is yet to come. The first is, I do think it should apply to critical nationally important transport and water infrastructure projects as well. Secondly, it's not entirely clear what the purpose of this first vote is to confirm the Minister's designation of the critical national importance priority, or rather, what's the significance of it? And it's also not clear quite when it would take place. There's a slight inference, if you read the policy paper, it might even be before submission of the DCO application, or it might be just afterwards. And certainly if the latter is the case, then there is the obvious concern that you have to wait for the parliamentary vote to take place before the examination can start. But as I say, what is the significance of designation? What flows from it in terms of the resulting DCO process? And then the next point is, what is the nature of the parliamentary process, including the second vote at the end of the DCO process? There are some concerns, I think, about whether it would be compliant with the Aarhus Convention, and we're going to hear more about that in a while. I'm a bit concerned that the procedure, a single vote this second time around in the House of Commons, is not likely to be substantive enough such that the courts accept it, accept that it should replace judicial review. And part of that same point, really, is we're told by the policy paper that the DCO will be afforded a distinct statutory status akin to an act, but it won't actually be an act of Parliament. And I wonder, is anything less than an act like you have with provisional order confirmation acts enough? And then the human rights carve-out. I think that is a recipe for environmental claims to be dressed up as human rights act points. And I don't think it's really necessary because, first of all, human rights points would be capable of being covered in the parliamentary authorisation stage if it was rather more than just a single vote in the House of Commons. And also we're told that the consequence of this authorisation will be that it will have the force of an act. Well, in that case, we know from the Human Rights Act that Parliament can decide to legislate in a way that's incompatible with the Human Rights Act, and that's clear from Section 19. And also, the Act makes it clear that public authorities, and it's unlawful under the Act for a public authority to act in a way that is incompatible with the Convention right. The Act makes it clear that public authorities, that phrase does not include Parliament or a person exercising functions in connection with proceedings in Parliament. So I think that Human Rights Act carve-out is a problem and will undermine the positive impact this change would have. And then a very final point. It would follow, I think, that if you have one vote in Parliament that then replaces judicial review of a development consent order, I think it would follow that national policy statements, which equally can be approved by a House of Commons vote, that in that case they would also, or they should also rather, be exempt from judicial review. And I don't know whether the government has thought about that or not, but it's an obvious point that follows, I believe. So with that, I'm going to hand over to my colleague Matt Fox, who's going to talk about the second element in the policy paper. Matt.
Thanks, Robbie, and morning, everybody. So yes, there's the second element of the policy paper, which talks to this idea of a challenge window. And I think looking at that proposal, there are the pros and cons to it. And I think the biggest con potentially is the fact that this will have the potential to add quite a lot of time to your decision-making process. It talks about essentially pausing the decision to allow for a judicial review to be lodged. And if that means making the judicial review process play out to its entire length, that can take 6 to 9 months, up to a year, even if it goes beyond the High Court stage, of course. And the fact that if that's a JR lodged on the basis of essentially a provisional decision, then you could have an instance where you'd have an objecting party having 2 bites to the cherry, essentially lodging a JR on the basis of the initial decision, and/or then deciding to, on the basis of the final decision, even if the Secretary of State had taken account of that initial JR, to then launch a second JR. So then you have essentially 2 lots of JR happening to your project, which is in no way meeting the government's objective to streamline the process. So there's definitely some work to be done, working with government to work through what this actually looks like in reality. But I think the biggest pro is that it does reflect the fact that there is scope, once the examination is over, to make sure that the decision is robust and able to be, if not free from challenge, then at least limiting the amount of grounds that the challenge would be brought on, and making it clear and bringing objectives to the table to draw out the key points of potential challenge. But I think this doesn't need to be done necessarily through the process as it's envisaged in the policy paper. It can be done in a way that it has, to an extent, already been done in some examples to date. And I'm talking in particular here around the recent Hornsey 3 and Gatwick Airport decisions, which, before the decision was made, had the Secretary of State issuing essentially minded to approve letters, which set out their thoughts on what the decision was going to be, and invited comment on them. And I think that that is something that should be looked at as a way forward for the kind of challenge window process that the government is talking about here. Because if you have essentially a draft decision, it doesn't need to be that draft decision itself is JR'd, but that draft decision is able to be commented upon. Because if you can get those comments, then the Secretary of State can think about how he or she is going to make that decision. So it allows the arguments to be flushed out, and enabling the Secretary of State to make as robust a decision as possible. I think what's important, though, is if you're going to have this kind of challenge window process, and as I say, not necessarily in a JR sphere, but more generally through the post-examination process, is to try and make that process as streamlined and with a certain set of rules. So what you don't have is, like, you have an examination almost, comments upon comments upon comments upon comments. At some point, somebody has to have the final say, and normally that is the applicant. And I think that's right, that you have a chance for Secretary of State's minded to decisions to come out, people comment on it, and then the applicant makes comments on what other people have had to say, but the Secretary of State then takes that into account. I think it's important that whatever this process looks like, that it's done in a way that focuses on the points in question, and is clear to people who are participating in any kind of challenge window process that the submissions that they make should be focused on the matters in question. So not absolutely every single thing, because if you start having people remaking comments, then it's a lot more for the Secretary of State to read, and a lot more for the Secretary of State to show that they've thought about and taken into account. So I think it's important to kind of streamline it, have set deadlines, and make it clear that it's about making new points. Another benefit that could come from this challenge window process is that essentially it seems like almost every single DCO that has been made by government has had to be subject to a corrections process to fix certain errors and omissions that has come through from the final order that is made as compared to the final draft that the applicant has wanted. And so I would encourage that whatever process is created here, that is done through not just setting out a minded to approve letter with certain questions, but also publishing the draft DCO to give a chance for the applicant and other parties as necessary to suggest further changes to the drafting, because ultimately it's the order that gives you consent and controls the nature of your consent. It's important, therefore, that everyone gets a chance to make sure that the DCO is right. So again, post consent, you're not waiting around for that corrections process to take place, which sometimes can be quick, but sometimes a recent one that Robbie and I have done actually took 6 years, which is an exception, but shows that it can take some time. And when it's a correction for an important point, for example, the drafting of a requirement, then that can obviously delay you getting going and discharging those requirements. So I think there's a lot of good. This is a good idea in concept, but there's a lot of detail, and I think that the crucial point is this doesn't need to be. I think we would all say a process where it's an initial decision and a JR gets lodged, but actually it's an initial decision with a chance to comment in a streamlined and managed way. With that said, I'm going to pass on to Claire, who's going to talk a bit about how other parties might look at this.
Thanks very much, Matt, and good morning, everyone. Just picking up on some of the points that Matt has raised, and I think whichever process is selected to go forward for this challenge window option, whether it's a ability to lodge JRs or, as Matt has suggested, sort of an issue of a minded to grant decision letter that people have the opportunity to comment on, what will be crucial to understand is what role each of the parties play in this process, and what that means in terms of cost and resources. We would expect the applicant to have a large role in this process, particularly because they are most familiar with the application documents and with the points that were raised during examination. During a typical judicial review, it is the applicant's team that will support the Secretary of State in any defence in terms of finding where in the examination particular issues were explored in detail so that it can be clearly demonstrated that points were considered. We'd expect there to be the opportunity for the applicant to have a similar role there, but again, that will lead to costs and resources for the applicant. Similarly, if this is going to be a more transparent consultation process than you would typically have for a judicial review, we would need to have some clarity on the role that stakeholders would play in that process, particularly now that the applicant is funding the costs of those stakeholders. So whether it's a need for parties like the Environment Agency or Natural England to provide comments on drafting, or the local planning authority, and equally whether that would make a difference if it's the local planning authority that is itself minded to challenge the decision. So lots of sort of practical considerations. If the Secretary of State is minded to make a change to the decision letter, then if it's in terms of the phrasing of the decision letter, that's sort of one element. But if there are changes to the drafting of the DCO, or particularly removing elements of the scheme as a result of concerns that have been raised, how will the applicant be part of that decision-making process? And will it mean that concessions are made that result in schemes being less viable than they were before? And also, could it mean that applicants and other bodies hold back on offering concessions or changes to schemes during the examination process, waiting to see if there are comments on a minded to grant letter or doing a challenge window, and then offering up those concessions only at that point in time? I think it's also important to remember that Judicial review often happens because local communities don't want the scheme there at all. So it probably won't deter bodies whose main aim is to get the scheme quashed. And there's a limit to the amount of changes that can be made during this process, particularly when concerns are to do with cumulative impacts or consideration of alternative sites for a particular project. Ultimately, I think it's really important for everyone to remember that whilst we can speed up the process, what will really limit judicial review going forward is making sure that the MPSs are really clear in their policies, and so it's easier for applicants to demonstrate compliance with those policies, but also, and this is points that have been picked up in various of the government's policy papers to date, that it needs to be much clearer to local communities how projects will benefit them, particularly in terms of job creation and the coordinated approaches that are required across projects to deliver those benefits to the people who are affected by schemes. On that basis, I will hand over to Isabella Tafur, who's going to discuss some of the public law implications of these proposals. Thank you.
Thank you, Claire. So as we've heard, the proposal is for parliamentary authorisation, which will involve a parliamentary vote to confirm the designation of a project as being of critical national importance at the beginning of the process, and a further parliamentary vote on the final decision at the end of the process. If approved, the decision would then be afforded a special status, which we're told would be akin to an Act of Parliament and could only be challenged on human rights grounds. Generally speaking, Acts of Parliament can't be challenged in judicial review either on substantive or procedural grounds. And that means, as the House of Lords explained in 2005 in the case of the Crown on the application of Jackson, an Attorney General, that the courts have no power to examine proceedings in Parliament to determine whether the passing of an act is invalid because of some procedural impropriety or substantive legal error. There is a narrow scope of review under Section 4 of the Human Rights Act, which empowers the courts to make declarations of incompatibility in relation to primary legislation, which is inconsistent with convention rights. But a declaration of incompatibility doesn't affect the validity or continuing operation of the statutory provision. It's not clear whether the government intends a DCO decision to constitute an Act of Parliament proper, because the publication refers to a decision being akin to an Act of Parliament. So whether it would have the status and protection from challenge of an actual Act of Parliament remains to be seen. That distinction is important because a statutory instrument approved by an affirmative resolution procedure in Parliament, i.e. approved by a resolution of each House, can still be challenged by judicial review on conventional grounds. And the procedure outlined in the government's paper arguably resembles a form of affirmative resolution procedure. If it is an Act of Parliament proper, it isn't clear whether the government intends a successful challenge on human rights grounds, voted on by Parliament, to result in just a declaration of incompatibility or potentially the quashing of the decision. Leaving that aside, the proposals create potential tension with other statutory provisions, international obligations, and established principles of public law, and I'll cover some of those and then hand on to Hugh. The first thing to consider is the court's approach to ouster clauses. Generally speaking, the courts are pretty hostile to statutory provisions seeking to oust their supervisory jurisdiction. And the seminal case on that issue is Anna's Minnick. But a more recent example from 2019 is the judgment of the Supreme Court in the Crown on the application of Privacy International and Investigatory Powers Tribunal. In that case, there was a statutory provision to the effect that determinations of the Investigatory Powers Tribunal, including decisions as to whether they have jurisdiction, shall not be subject to appeal or liable to be questioned in any court. And in that case, a majority of the Supreme Court found that that wording was not explicit enough to exclude judicial review. They did suggest that a more explicit formula may have been capable of excluding challenge. For example, if the provision referred to any purported determinations by the tribunal. even if the wording was explicit, Lord Carnworth expressed the obiter view that binding effect couldn't be given to a clause which purported to exclude the supervisory jurisdiction of the court, and that in all cases, regardless of the statutory wording, it would be for the court to determine the extent to which an ouster clause should be upheld. However, in the event that Parliament legislates in very clear language to oust the court's role in certain NSIP decisions, any attempt by the courts to circumvent that ouster would likely give rise to constitutional issues around the sovereignty of Parliament. The second issue to consider is the right to a fair hearing. In Alconbury, the House of Lords held that the Secretary of State's power to determine planning applications and appeals was compatible with the right to a fair trial under Article 6. Although the Secretary of State was not an independent and impartial tribunal because of his role in promulgating national policy, provided his decisions were subject to review by an independent and impartial tribunal, which had full jurisdiction to deal with the case, there was no breach of Article 6. The House of Lords placed some emphasis on the fact that the court had full jurisdiction to review the decision, and also on the breadth of the grounds of challenge available under the modern ambit of judicial review. So if JR is excluded for all but human rights grounds, as the government proposes, a question arises whether a decision would still ultimately be compatible with Article 6. And a factor that the House of Lords took into account in Alconbury was that in the majority of cases under the Town and Country Planning Act, there were procedural safeguards, such as the holding of an inquiry, which gave the applicant and objectors the opportunity to put forward their views, with the inspector's report acting as an important filter before the Secretary of State took his decision. That safeguard arguably applies to all NSIPs, where any decision of the Secretary of State would be preceded by an examination and report by the examining authority. However, that didn't detract from the court's finding that to ensure compatibility with Article 6, decisions by the Secretary of State should be amenable to review of the legality of the decision and the procedures followed. So as I say, any attempt to restrict the scope of judicial review and the court's supervisory jurisdiction could arguably give rise to concerns about incompatibility with the process under Article 6. And with that, I will hand on to Hugh.
Thanks, Isabella. So I'm just going to now deal with two matters. Firstly, the Aarhus Convention and compatibility, then talk a bit more about human rights challenges before concluding. So on the Aarhus Convention, many of you will know, ratified in 2005 by the government, confirmed the right to public participation in decision-making and access to justice in environmental matters. And ratification gives rise to obligations on the UK in international law. And each ratifying party has committed to ensure the members of the public with sufficient interest have access to a review procedure before a court or other independent body to challenge the legality of the decision. And that also mirrors, importantly, the requirement in Article 11 of the EIA directive. The UK's compliance with the Aarhus Convention is monitored by the Aarhus Convention Committee, which has in the past found the UK to be non-compliant. And then the final element of the legal framework is the EU-UK Trade and Cooperation Agreement, giving effect to Brexit, which provides that a party shall not weaken or reduce in a manner affecting trade or investment its environmental levels of protection, which limit, and that effectively limits the scope to diverge from the current EIA regime. So, I mean, at first blush, a provision which prevents challenges altogether, other than on human rights grounds, might be said to put the UK in breach of its international obligations under the Aarhus Convention. But there is clear precedent that in European case law that neither the EIA directive nor the Aarhus Convention applies to projects which are adopted by means of a legislative act, provided that the legislative act is a substantive process and not just formal ratification. And therefore, that, as Robbie's sort of trailed, that raises a question about the type of parliamentary procedure that would be taking place. If it is a substantive process, then it's likely to be compatible with our international obligations under Aarhus, because the legislature is conducting the exercise that the court would otherwise do. If it's more of a rubber stamping exercise, however, that really does create arguments about compliance with the Aarhus Convention. So that's the Aarhus Convention. Then next, human rights challenges and the scope for that. So there's the first aspect is Article 6, the right to a fair hearing. And as Isabella's indicated, there's potential issues in respect of the Olkenbury case and how compatible it would be with that. As to other human rights aspects, there's probably two particular ones. If the DCO includes compulsory acquisition powers, and those would be Article 1 of the first protocol, the right to property, and secondly, Article 8, the right to private and family life. And the full breadth of those rights should be appreciated, that they go beyond a sort of narrow reading. The European courts interpreted them broadly, and also they're important because the UK courts, if human rights are involved, look at the proportionality of the decision, and that involves them getting into the substance of the case and not just taking a kind of supervisory review jurisdiction. So it does enable the court to sort of drill down into the detail. And for a recent example of that, there's a case which Rebecca and I were involved in, the Corrie challenge, which is judgment is pending, but that included challenges on both Article 6 grounds and Article 1 of the first protocol, challenge to a DCO by someone whose land was being acquired. In terms of other rights, there's potentially also the Article 2, the right to life, and Article 14, non-discrimination. And those claimants have tried to raise those in the context of environmental challenges in the past, particularly climate change, where people's environments are going to be transformed by rising sea levels and things of that sort. Those challenges have been not hugely successful so far, but if the only challenge is going to be on human rights grounds, you might wonder whether people might try and expand those and have another go at raising those. So that's the sort of outline of the human rights aspect. And then just finally, a few concluding thoughts on the public law aspects of these changes and the parliamentary authorisation process. And it seems to me that these are fairly deep waters. Parliamentary sovereignty provides the ultimate protection against challenge, but conventionally that requires an act of Parliament. And the policy paper, interestingly, proposes something that is a distinct statutory status akin to an Act of Parliament, but therefore not an Act of Parliament, something bespoke and novel. It's not a hybrid bill, as Robbie's indicated, not a provisional order confirmation bill or some special procedure order that have existed and been used historically. And undoubtedly there are those procedures, and if there weren't, you could create a new one in Parliament to try and give effect to what the government want to do here. But the real question, it seems to me, is whether they're going to be substantive enough to satisfy that line of case law which says that only if the legislature substantively considers the measure that it then becomes compatible with Aarhus to remove challenge. And the difficulty there, or at least the issue to be worked through, is balancing that desire for a need for substantive consideration by Parliament and the desire to do things quickly and be expeditious, which is obviously a principal aim of the government's reforms. And bearing in mind that Parliament's very busy, it's hard to get parliamentary time. There's also the constraints of parliamentary terms. So ensuring robust and substantive consideration by Parliament, but doing so expeditiously and not holding things up is the tightrope to be walked, probably. And then finally, just to observe as well that this is obviously at the moment, the proposal is limited to energy projects, and not just all energy projects, only ones which come within this category of sufficient national importance. So there's a filter in place there. Things like a future large-scale nuclear power plant might be thought to be within that category, but those don't come along very often. And if it is limited to that category, you wonder how effective it's going to be generally, and whether there might be then political pressure to expand it to a wider category to show tangible benefit. So I'll just leave you with that thought, and at that point I'll hand back to Harry. Thank you.
Thank you, Hugh, and thank you to all of our speakers. Really interesting range of issues that are thrown up by these proposals. And whilst I think there's general consensus amongst us that the objectives that underlie these proposals are in the public interest and to be welcomed, there's clearly a long way to go in fashioning the detail of this and working out the legal implications of it. Now, we've had a number of interesting questions raised. We don't have time to deal with all of them, but I'll just pick out a couple and I'll offer some initial thoughts and then see if any of our panelists have anything to add. The first question is well, why wasn't the original paper stage effective? Relatively low cost, and were judges not doing a good enough job? Which is an interesting question. My own understanding is that I don't think the reform was based on any suggestion that the judges weren't doing a good job at the paper stage. It was more about the number of times that claimants were being given an opportunity to run out cases which were of limited merit, and how much time that took. So I don't think it was based on that particular concern, and certainly in my experience the paper stage was quite effective, but not necessarily cheap, because it's an opportunity to put forward your case, and most people responding will take the chance to put their best foot forward and incur a lot of the expenditure up front. So I'll just see if any of our panelists have anything to add to that before I move on to the next question. Doesn't look like it. So the next question is whether there's an indication of the timeline for these reforms. Now, I look back at the paper that was published in May. That doesn't seem to contain any particular timeline. I don't know whether any of the other speakers are aware of anything that's outside the paper in terms of timing. Again,
I can probably try and help,
Robbie.
Harry.
Yeah,
I can try and help. I think government wishes to carry out the detailed design of these proposals over the course of the summer, because they've got some bills coming along. There are 2 or 3 energy bills. There's a clean water bill that would be, I think, appropriate vehicles for these reforms to be made. So I think we're looking at probably the process taking 4 to 6 months, so the second half of this year to do the detailed design. But that's the only time frame I'm aware of, and some of that is speculation.
Well, Robbie, no doubt well-informed speculation, but thank you very much for that. That sounds like probably the best we can offer sitting here today. Well, look, I think we've really run out of time now for further questions, so I'm sorry we weren't able to get to all of the questions that have been posed. But thank you very much to all our speakers, and thank you to all of those who've joined us this morning for what I hope you found an interesting and useful session. So thanks once again, and we hope to see you in the future for similar such events. Thank you.